Just want to say thank you to everyone, the participants, the discussants, the attendees. In the law school, we all know that the most valuable gift you can give is your time, and I appreciate all the work that has been put in to make this a successful event. Just one quick announcement. When this panel concludes, there's going to be a reception in the Star Commons mezzanine right over there, overlooking Star Commons. So please feel free to go over there and get some refreshments, mingle, answer any questions you may not have gotten a chance to do during these presentations. And also, if you are a driver, that you're driving a participant to the airport, please, if you have not already done so, introduce yourself at the end of this panel so that everybody knows each other's face and we can make sure that folks get to the airport on time. And in case there's any alterations in the plan, we can make sure that everybody's on the same page regarding that. So, heading up our last panel, we have Professor Julian. He's from the Maurice A. Deane School of Law at Hofstra University. His primary research interest is the relationship of international law to constitutional law. He's also conducted academic research on a wide range of topics, including international dispute resolution, international criminal law, and China's relationship with international law. He teaches courses such as U.S. constitutional law, U.S. foreign affairs law, transnational law, and international trade and business law. Our discussant is Professor Ralf here from Duke University School of Law. He's an expert in comparative law and conflicts of law. His current research focuses mainly on three issues: the role of domestic courts in globalization, the role of conflict of laws as a theory of global legal fragmentation, and the status and relevance of law beyond the state. He's authored numerous articles on all three topics. And Professor Ku's paper topic is Chinese Views on Government Official Immunity. With that, please welcome them.
Thanks a lot, and I really want to give my thanks to all of you for, especially the organizers of the conference for inviting me down here. I always enjoy coming down to North Carolina, and also just to students. I think this is getting hard. Friday afternoon, 3 p.m. I'm not usually awake at this time, so neither should you. I do appreciate you sticking with me here. And I did also, as always the case, I always learn a tremendous amount just from attending these sorts of symposia, and a lot more than I'll be able to give back in this case. So I really do appreciate the chance to be involved. Now, as my bio suggests, I'm primarily a scholar looking at the relationship between international law and U.S. constitutional law. So the question of foreign government official immunity in U.S. courts is something I've long been interested in. But in the last few years, I've also been pursuing a research project looking at the Chinese government, and its treatment and usage of international law. And so this topic gives me an opportunity to sort of blend these sort of interests together a little bit and thinking about the treatment of sovereign immunity in U.S. courts, and also the evolution of China in their use of and treatment of international law. So with that, I'm going to try to put these two things together, even though, as I think like Professor Wilson, my talk's a little bit off the main track of this symposia. I do think it has an important connection. So in the last few years, there's a lot of talk about, if you just sort of read the newspapers or read certain policy journals, especially international relations journals, the rise of China is a very trendy phrase. I think it's probably reached billions of Google accounts. And it's not because it's made up. China is now the number 2 economic and military power in the world, and it also has an outsized influence in many international organizations. It's just a quick example. It has a permanent seat in the United Nations Security Council, and yet, in my view, its influence on international law and the development of international law has been understudied. Most of the literature in the U.S. sort of focuses on how China can or should comply with international law, or how it doesn't, but it should. But not on what China actually thinks about international law from its own point of view. And so my project has been to take seriously China's views on international law, and to try to understand whether there are distinct interpretations or views of international law, and evaluate those on their own terms. And I look at statements by the government, but also from the growing domestic community of international lawyers in China. Unfortunately, most of those people write in Chinese, and my Chinese is good, but not that good, so it's always a little slow when I work through their materials. But I think it's still worth doing, because I think it's necessary to better understand the way China itself looks at international law. So today I'll look at one area where China has issued views on international law, and that's the international law of sovereign immunity for foreign government officials, which is conveniently the topic for today. And I want to begin by looking at China's unique view of the concept of sovereignty itself, which is China has I argue, a unique view, well, not unique, but a distinct conception of sovereignty that affects its view of the doctrine of sovereign immunity, and that explains to some degree some of the ways China has come out on some of these legal issues. So I'm going to talk about China's view on sovereign immunity, and then why I believe that China will have a strong opposition, and has already expressed a strong opposition to an exception, a jus cogens exception to sovereign immunity in foreign courts, either for foreign government officials or for the state itself. Okay, so let's talk a little bit about China and the concept of sovereignty. I begin with a quotation by the remarks of then Chinese Prime Minister Lin Jiabao to the General Assembly of the United Nations. In his speech, he has a little quote I pulled out. China's persistent stand on the primacy of state sovereignty has its deep roots embedded in the miserable experience of its modern history. Respect for sovereignty and non-interference in the internal affairs of other countries is the prerequisite for sound state-to-state relations. The Chinese people have learned from their modern history of humiliation that when a country loses sovereignty, its people lose dignity and status. And I picked this as just one of many statements of the similar kind made by Chinese leaders, made by Chinese newspapers, made in Chinese textbooks. You can just keep going with this. The key theme here is miserable history and then sovereignty as a solution. Now, just a quick note for those of you who aren't experts in Chinese history. What is this miserable experience? If you only watch the Olympics in 2008, things seem pretty chipper over there in China. But in fact, in China, there is a conventional Chinese history, especially what's the education in China today for young people and such, is that Chinese history since 1840, when the British launched the Opium War, which opened China but also subjected China to colonial sort of semi-conquest, is just one series of humiliations by foreign governments. So after the Opium Wars, China was forced to sign a bunch of treaties. Among these treaties, it required China to exempt foreigners from its domestic jurisdiction even when they lived in China. Then they also had to give over land to foreigners, like the city of Shanghai, the city of Hong Kong, the city of a bunch of other places. And in those areas, Chinese law had no applicability. Chinese citizens could be dragged into these jurisdictions and would be subject to foreign law even though they were in China. And there's all sorts of other things. And then eventually the Japanese invaded, took away various pieces of China, and then they invaded again and occupied the whole country. So it's just one series of disasters after another. And the common theme here is we're no longer in control of our state. There's actually one nice feature. I remember one treaty where the foreign countries took over China's tax system, and they took the first cut of the taxes. And then they gave what's left over to the government. The Chinese government, again, this is something the Chinese government teaches all their little kids. Remember when the British took your tax money away from you and things like that. So this is national humiliation on a grand scale for over 100 years, culminating in occupation by Japan, brutality, et cetera, et cetera. All right, so I don't want to make light of it. Just the point is that this narrative is strong. It's powerful. It's also true to some larger degree. And the solution to this, ideologically and historically, is sovereignty. China needs to be sovereign. It needs to be independent. It needs to be separate. And it needs to rise up and be independent of all these foreign countries. It needs to be strong. And so it's not surprising that China has, once it finally did achieve political independence, kicked out the Japanese, et cetera, that one of the main principles of Chinese government with respect to its foreign policy was to insist in almost all of its public statements on the importance of the principle of sovereignty. And so they issued in 1954 the 5 Principles of Peaceful Coexistence, which largely are about sovereignty, non-interference in foreign affairs. And the one idea behind all these 5 principles is sovereignty and mutuality and equality. So it's not just sovereignty, meaning we're independent, but equality, meaning that we're equal as a sovereign to other countries. We're not some sort of lesser country. And so this insistence on not just sovereignty and independence, but sovereignty and equality, I argue, is part of the explanation for how this Chinese government has interpreted the doctrine of sovereign immunity, which the Chinese government and Chinese scholars see flows directly from the concept of sovereign, not independence, but sovereign equality. If you're not equal of other sovereigns, then they might just drag you into their courts, drag your officials into their domestic courts and subject them to jurisdiction, whereas they might not do so for other sovereigns. But the principle of sovereign equality is that every sovereign, including China, is equal to every other sovereign and deserves the respect and dignity of every other sovereign, and therefore you can't just drag us into your courts and sue our officials and take our property, etc. And so that's why, and so then that's, I think, I argue this emphasis in the Chinese literature and Chinese ideology of the government on sovereign equality. It explains why China today is one of the few countries that adopts an absolute, what the so-called absolute immunity in sovereign immunity. So they have they hold absolute immunity in cases of acts of foreign states from national jurisdiction and execution. Is a view that, and I'm quoting from a leading Chinese scholar, is a view that the principle of immunity is a right of a state, a right under customary international law, rather than a comedy. In its own judicial practice, Chinese courts have neither exercised jurisdiction over acts of foreign states, nor have they enforced any decisions involving public property of foreign states. And there are no exceptions to this doctrine. The restrictive theory of sovereign immunity that was embodied in the Foreign Sovereign Immunities Act, which has been sort of taught to generations of law students, as some of you mentioned earlier today, is not something that China has embraced. China is actually resolutely opposed to it. Now, there's some, I discussed briefly in the paper, there's some thought maybe they're going to move away from that. But in a 2011 decision, the Chinese central government actually ordered the courts in Hong Kong, which had previously followed a restrictive theory, a somewhat limited theory of sovereign immunity for commercial activity, had ordered the government of the courts in Hong Kong to switch the rule and to adopt a rule of absolute sovereign immunity, even for commercial acts, as long as it involved a foreign state. And so that I think that's sort of not related directly to what we're talking about here, but I think it gives a background for like Chinese conceptions of sovereign immunity. They have a relatively absolutist conception of sovereign immunity, driven by the principle of sovereign equality, and an equal has no power over an equal, right? If we're equal, you can't drag us into courts. And also, I think it's reflected in Chinese reactions when their officials are sued have been sued in the United States for violations of human rights abuses or human rights principles. There have been several such lawsuits. You heard reference to it earlier today. Both Mr. Bellinger and Professor Bradley were actually involved in some of these cases. Chinese officials were sued, usually in most recent years, by a group called the Falun Gong, for various, very serious abuses that were alleged to have occurred in China. In each case, the Chinese government has filed very strong statements, some of which have become public, to the U.S. State Department, demanding absolute immunity for all of their foreign government officials, even for a Minister of Commerce, Bo Xilai, which I think was also mentioned earlier, who is not a head of state. And the argument was, well, but the memo they sent to State Department did not distinguish between different types of immunity, but they did insist that he be given immunity from U.S. courts. The State Department took that and ran with it and came up with this special missions theory of sovereign immunity to get out of that situation. And also in other cases they've sued head of states. But the Chinese government has not made this distinction. They've generally asked for and demanded absolute immunity for all whenever their government officials are sued in the United States. This actually goes way back to the 1980s when old Chinese bonds were Chinese bonds from a previous government were floating around the U.S. and someone finally brought the Chinese government to suit for them. And again, the U.S. government's initial reaction was these bonds are commercial activity. There's no immunity for it. The Chinese government came in with a blistering memo to the State Department saying, we have absolute immunity. Get us out of this case. And Deng Xiaoping himself, the paramount leader of China, called the Secretary of State of the United States to Beijing and said, get rid of this case now. And the U.S. government duly did get rid of it on a complicated theory of retroactive sovereign immunity. So the Chinese government has not been very subtle, although they've evolved in their views on this. But I think it's fair to say they are skeptical that there could be exceptions to sovereign immunity for foreign government officials. They agree that there is. They have argued on behalf of their foreign government officials that they deserve immunity, and in general, they have an absolutist conception of immunity. I think it's reflected also in Chinese statements made to the General Assembly, Sixth Committee, and also the International Law Commission, although we don't know exactly which countries say what in the International Law Commission. But with respect to some public statements and also some works of Chinese scholars, the government has emphasized a distinction between a state asserting criminal jurisdiction, which is what they're usually concerned with, or jurisdiction for international crimes over, say, the Chinese government or some other government, versus an international organization. And this distinction is familiar. It's not something that China came up with, but it makes sense, again, from their conception of sovereign equality. The Chinese government does not oppose necessarily to criminalizing serious international crimes, or not necessarily opposed to use Kogan's, but they strongly oppose any individual state asserting its power to enforce these international criminal these international crimes or use Kogan's violations, ignoring or overcoming the principle of sovereign immunity. Why? Well, the thought here is that the existence of state criminal jurisdiction over foreign government officials is subject to abuse and politicization, right? This could very well, even if there's a serious crime there, the very existence of one state sitting in judgment of another state is such an unstable, ripe situation for politicization and abuse that it's not worth it, or it's improper for the state to try to enforce these international norms. So it's procedural protection it's a procedural protection for their state official, for the states and their officials. And the goal is, as we understand it, I think this is also true for other countries, is to maintain good state-to-state relations. If some international organization, perhaps, were to assert jurisdiction to punish international crimes, that would not raise the same issues, right, of sovereign immunity of foreign states. And the Chinese government has made this type of statement as well. And so I think that it's fair to say that, although they've kind of worked around this, I think it's fair to say the Chinese government is probably not going to support a clear exception to foreign sovereign immunity in state courts foreign sovereign immunity in state courts, but they might not necessarily be opposed to allowing punishment through an international organization. It's also, although again, it's a little bit uncertain because, of course, China has not joined the International Criminal Court, but they have supported the work of some of the other international ad hoc criminal tribunals by having staff work there, and I think sending some money, in some cases support some of the international criminal tribunals ad hoc. But they have not joined the International Criminal Court, nor is there an indication that they intend to do so. But I think that it reflects the distinction between an international organization punishing a youth Kogan's crime versus creating an exception for states to do so is really at the heart of their view. And it flows directly from, again, what I'm emphasizing is this historical emphasis on sovereign equality and making sure that China is equal to other sovereigns and not being subjected to or being judged by the domestic processes of another jurisdiction. So I've dug up some sort of scholarly articles, which I'm still working on getting more of them, which I think reflect the view among Chinese scholars also that despite this seriousness and the importance of youth Kogan's violations, it cannot overcome the importance of the principle of sovereign immunity. So I think that's fair to say that's probably where they come out. So I think that, and I think this is not something, again, unique. I think this position actually is shared by many states, not just China. What I'm trying to emphasize, though, is that China does have a sort of historical, it's not just a political sort of, a political expediency to avoid jurisdiction. There's some sort of historical basis, ideological basis, and other basis for their very hardline view on sovereign immunity. Now, let me sort of conclude by sort of focusing on some of the sort of the bigger questions I started with. Does it matter what China thinks about this subject? I think we could go for the Fourth Circuit, when surveying views of foreign countries, is not going to cite Chinese views on sovereign immunity. Scholars do not generally, in the United States at least, cite China's views on sovereign immunity, largely because there are very few Chinese cases, there are very few Chinese scholars writing in English, but maybe it's also because their views don't matter. And that's also an interesting possibility. We do, in the United States, typically mostly look at foreign sources. We look at other common law jurisdictions, which conveniently write in English. And we look at European jurisdictions, which also conveniently translate things into English. And then for those of us who are good enough to read foreign languages, you might look at foreign languages, but it's such a pain. Those of you students who research in foreign languages, you may say, oh, I can speak Spanish. Yeah, right, go read that document in Spanish, right? So it's not that easy to do this cross-lingual research. Professor Michaels can do it. The rest of us can't do this quite as easily. So you end up seeing citations. Well, the international community thinks X. You almost never see a citation of what China thinks about anything with respect to international law doctrines. Does that matter? I think there are reasons to think maybe we don't really care about their views. But then you hear at the same time, and this is the last thing I'll just conclude with, the rise of China. It's hard to avoid that language, people talking about China as the next superpower, the next hegemonic government, they control everything, et cetera, or at least they're maybe the second most influential country in the world behind the United States, or maybe third behind Europe. And that, how is it possible they will have no impact on the development of international law? If the second most important country or third most important country in the world continues with an absolutist opposition to any sort of exceptions to sovereign immunity based on principled grounds, based on their history, what's the likelihood that the law will change in a way against that view? Probably, I think it might still do so, but I think it's worth thinking hard about whether China's new place in the world, its sort of heightened status in the world, which should cause us to rethink how we think international law will develop in this and many other areas. So I'll just stop there.
So fabulous. Thanks very much. Of course, among the not that many languages that I do read, Chinese has no place. So, and it is true. I think it's not true. I think there are scholars who write about China's importance. There are scholars who make the point that China should influence international law, but few of them read Chinese themselves. And so I don't trust them more than I trust myself, and I don't trust myself very much on this. So one big service that Julian does in this already is that he's one of the few among us in international law who has for some time now focused on China and looked at what China does and also internally. And that's a huge, huge contribution and very helpful. I want to make a few comments, and maybe they raise questions and maybe they do not. But I want to say before on this accessibility problem, I think that has changed in recent years. We do have the occasional publication about Chinese law, including from Chinese scholars. We have official positions. The ones that Julian named actually are accessible in English. The Chinese government translates them. We have a Chinese Journal of International Law that has a fair amount of scholarship on these questions, including a very recent one on the topic of the ILC project. So even people like myself and many of you who don't read Chinese have some access to these by now. This is something changing. So in the sense that China would need to be accessible to play a role in international law, I think some of that is happening by now. I think to start Julian's point that China has been very consistent in maintaining an absolute theory of sovereign immunity as opposed to restrictive theories of immunity. That's quite certainly true. So China has constantly maintained this position in official positions. It has maintained that as far as we can see in its own case law. We don't seem to have cases in which immunity was not granted to foreign states. It has consistently emphasized this in foreign courts, including in the United States and in others, in the recent Falun Gong cases all over the world. And it has indeed, as Julian says, imposed this on the Hong Kong courts quite recently, although I'll say something more about that case in a moment. The one half exception that I'd just be very interested how it happened was China's support of the 2004 States Immunities Jurisdiction Convention. The UN Convention, a document that was written in large part in the leadership of China. The official text is in Chinese. The Chinese delegate says this is not optimal, but we think it is very good, and we hope every country will sign and ratify this. And then it appears into limbo again. The Chinese themselves don't ratify it, and now explicitly distance themselves from it by saying we didn't ratify it, so it doesn't bind us. People make the argument that under the Vienna Convention they have to somehow comply with this, which is this usual argument in international law to say you signed it, now it doesn't matter anymore whether you ratified it or not. That's probably not a strong international law argument, but it is one puzzling element in the history. My sense is it was the hope that Julian mentioned of China to say we can somehow raise these questions from a domestic state-by-state level to an international level, and that would be attractive. Nonetheless, that is also one in which China grants some consent to a restrictive theory of jurisdiction, as appears in that convention. And so that's the one thing in that history that would need to be explained somehow. This is an absolute theory of absolute immunity, so it makes no distinction as far as I can see between criminal and civil. It does not seem to make a distinction, obviously, between public acts and private acts, commercial acts, and it does not make a distinction between use cogence violations and other acts. There's an argument that all of this could be treated differently, but under that approach they're not, and as far as I can see, there's no way to see whether the Chinese would waver on one aspect and not on the other. I want to say some words on the background that Julian emphasizes, the historical background. So the argument that China makes on the importance of sovereignty for a country like that feeds into two themes that we have in the 20th century history of international law. You know that international law at some point explicitly says this is law made by civilized nations, which explicitly means not China. And so there's a quite deliberate pro-Western, pro-European bias at some point. And there are two ways of opposition to that, I think, that you see in reactions. One is developing countries that say international law is to our disfavor, in many regards also in sovereign immunity. Because they say, for example, the commercial exception means effectively that big first world corporations can undermine our sovereignty. The old argument to say we have political sovereignty, but we don't really have economic sovereignty. And that is something that China plays on, I think, because the early 20th century history is one in which effectively Western nations take over, not politically, China is not actually colonized, but economically and in terms of effective exercise of sovereignty, take away a lot of that. So that's the developing country argument, if you want. And for China, that's particularly strong because China has a tradition of being strong and important in Asia, of course. The second is an argument historically of socialist countries that said this whole idea, especially of a commercial exception, relies on a public-private distinction that is not applicable to socialist countries. That's a bias. There's a Chinese position that actually says this is biased against socialist countries. So part of this Chinese opposition also comes from this idea that this is capitalist international law as opposed to socialist international law. We do have, in fact, I looked at that, we have a treaty between the Soviet Union and China where they respectively give exceptions to sovereign immunity. So among socialist countries, this seems to be okay. But at that time, at least, vis-a-vis Western countries, that was not okay. The odd thing then, of course, with all the history is that both of those things no longer apply. So China is no longer a developing country, first. And China, in many ways, is no longer a purely socialist country. And we have a rise of individual rights, emphases, etc. in China. And so although the pedigree of this is very long, my question is whether this history really still applies today. So that's one other question I want to raise. The first is the question of, or three questions actually. The first is what's the relevance of this in terms of law? So China, among a minority of countries, but some countries still maintains a theory of absolute immunity as opposed to restrictive immunity. That could either mean we do not achieve a rule of customary international law that establishes a restrictive theory, either for commercial exceptions or for use cogence exceptions, etc. And in that sense, obviously, China should be relevant. That feeds into the broader question, how do we see a rule of customary international law emerging? How much consensus do we actually need? In that context, I would think it would be necessary to look at countries like China and not just as countries that support one's position. It's worth mentioning perhaps, though, that the Tate letter, for example, does mention China, right? So it's not the case that the Tate letter that establishes sovereign immunity in 1952, I think, does look at several countries. China is among them. So if we do have a customary international law rule, it still wouldn't matter very much to China because China's conduct certainly qualifies them as a persistent objector. So we would still say this would not apply to them. The bigger point that Julian seems to make, and that's my second question, is this is not a question for law, this might be a question of politics. Can we still ignore China given that it's the third or second most important country in the world? I assume he means the United States is the most important country in the world. That's a political question, but that's a worrisome question in some ways, right? Because effectively, of course, it's going to be hard to ignore strong countries. And so his prediction to say that courts are unlikely to go against China's emphasis on immunity effectively may be correct. From a legal perspective, it is, of course, problematic because we would ask ourselves, is the only reason that China matters today, in fact, that they are so important now economically and from a military perspective? Of course, we have to ask that ourselves as well, because the same question obviously arises for the United States. Is our importance in international law really based largely on our own geopolitical importance and strength? But it does, of course, raise the question, will we yield to China in this way, in the sense that courts will have to move away from a restrictive immunity? Or the flip side, will China move away from its position on absolute immunity to one of restrictive immunity? We have some predictions that the latter might be true, at least for the commercial exception. So the Hong Kong case that Julian mentioned, a 2011 case, is an extreme case in some ways. This is a vulture fund that purchased a claim against the government of Congo, and it forces that into a claim that the government of Congo has against China from China's involvement, economic involvement in Africa. So there's huge, on the one hand, there's a huge political background in this, maintaining the big Chinese investment in Africa that is happening at the moment. And on the other hand, the relatively reduced sympathy that we have for vulture funds, perhaps. And so as strong as the Chinese government comes out in this in 2011 in this case, it might still be an exceptional case. The Hong Kong community is very critical of this, as this will undermine the importance of Hong Kong as a place for arbitration. It will undermine investment arbitration. And so my prediction would still be the more China is involved in world trade, the harder it will be to maintain opposition to the commercial exception, at least. The use cogence exception that plays more of a role here might be a different matter. So that's the second and the third, and I'll just mention that very briefly. In the end, I am not sure this is so much about China or about the United States. Many of the arguments that Julian named in the end says that here's China's position. Those are positions that we also find in the United States. So in some ways, we have a move of China possibly away from their original position towards one that looks at immunity in a more nuanced way. And we have at least positions in the United States that try to move towards a more muscular idea of sovereign immunity. And they're both strong countries. So in that regard, their interests tend to overlap. And so my prediction is much of this will matter, but it will matter not as a Chinese position versus a US position, but just as a strong sovereignty position versus an individual rights and commercial rights position. And as such, and then substantively, I expect it will be discussed in the future. Thank you. But thanks, Julian, for bringing this comparative aspect in. Thank you.
Speaking, I really appreciated the historical lens that you put on the, I guess, talk from the very beginning. But I mean, that's the tail end of 5 millennia of Chinese history. I would argue to say the rest of which had China as the dominant force in the world. And yet, even when China was the hegemon, the most developed country in all of the world, it did not attempt to necessarily exert a cultural influence on the countries around it. I mean, it was looking for tribute from many countries, but didn't necessarily have a colonizing bent, for the most part, from my understanding, which I'm sure you know 5,000 times more about this than I do. So my question is, does that part of China's history, the fact that it sees itself as the center kingdom, somewhat isolated in many ways from the rest of the world, self-contained in many ways, does that shape how China is trying to engage with the international community? In other words, does China even care what its influence on customary international law is, as long as China gets left alone? Do you understand my question?
Yeah, no, it's great, and I think it goes with Crystal Michael's a good challenge, which is maybe we and maybe China needs to reconceptualize its place in the world. I think the traditional and still the prevailing conception of China, even today, is that China is still a developing country, even though some people might disagree. Under the World Trade Organization, by the way, China continues to argue it should be treated as a developing country for a variety of reasons, which sort of makes sense. And so but maybe it's worth reconceptualizing its role, and maybe that'll affect how it will take a look at these doctrines, right? So if it's, and I think that is something that's worth thinking about. I think in terms of its sort of I think from my own take, my what I was trying to bring across in sort of my very sort of almost not very serious historical review of the history is to sort of to situate China. They don't look at the pre-modern, especially because international law itself seems like it's new as well. It all came together. The British, their warships came, and they came bearing international law textbooks as well. And none of that was really dealt with seriously. There was no Chinese translation of any international law textbook until 1850 by an American missionary. So they just weren't really focused on this issue. And so it's hard for them then to think of these issues in the pre-modern context. But I think it's worth thinking about. So what is there? And is it the left alone, or is it the we want to be involved in the world? I'm not suggesting China has any sort of, imperial ambitions and such. Although I think there's plenty within China's relationship with its neighbors for them to sort of everyone to be a little nervous exactly about how things will shake out in the future. So I'm not so sanguine about that. But I agree with you. But I'm not sure China's strategy has traditionally been leave us alone, and this doctrine fits with that strategy. Leave us alone. We're absolutely sorry, and don't interfere in our domestic affairs. And by the way, we're immune, so when we travel to your country, you can't bug us about that either. So this works with that. If Professor Michael suggests that this will change because China's role in the world will change, that is interesting. My guess is that hasn't happened yet, that because they still see themselves in this older way. And I'm not sure necessarily, on this last comment, I'm not sure that the new role would change. What if China became more like the United States in some respects? I'm not sure that would shift its view on, for instance, and I take his point on the Hughes-Kogan's exception. In a lot of ways, their arguments the Hughes-Kogan's exception could be drawn from many U.S. scholars, right, and the U.S. government itself in some cases. So it's not something that necessarily, so maybe that they'll evolve toward a more U.S. perspective on things, the U.S. as a superpower perspective on things, than the developing country perspective. I'm not sure that would result in big changes, but I do appreciate you raising that point about the pre-modern history is worth thinking about.
Yeah, maybe person.
Kind of a little bit furthering on that discussion, I was wondering, is there any argument that China is kind of losing with the strategy that it's been taking towards international affairs? Like, why is China disadvantaged by this approach? I know we keep talking about reconceptualizing China, but then my question is still, who is doing the reconceptualizing? Is it that China needs to be doing it and it's not? Is it that we need to start understanding China through a different lens in order to better understand, what their general strategy is going to be in the international world, or what? So I guess the narrow question is, what's the downside? And the second related question is, who should be doing the assessing? Is it China or us?
I'm sorry, the downside of what?
The downside of their current strategy, which is essentially kind of leave us alone, and we'll just have like a very simple, we do what we want and just don't be in our way kind of strategy.
Well, I think that, I don't know, it's tempting to stick with it. I think the general assessment from foreigners has been this can't work as China becomes deeply intertwined in the world, right? There are millions and millions of Chinese nationals traveling, there's billions of investment, and they just, for a variety of reasons, it's hard for them, and they're the biggest trading nation in the world, so it's hard for them to stay quite as isolated, and plus they have these weird border conflicts with all their neighbors. So it's hard for them to be completely isolated as they were in the old days, I suppose. And that's why it's hard. So that's why many people think, things need to be reconceptualized. Also, I think China does play a big role because it's been given a big role in a lot of international organizations, like the UN, the World Trade Organization, and for good reason, perhaps. So what do they do with this? What do they do? They always have a judge on the International Court of Justice now. They always have a member of the World Trade Organization appellate body. They kind of get the American treatment a little bit. And so what will they do with this sort of outsized role they have in these global institutions as well? I think it's worth thinking about. In terms of who's going to think about it, obviously the Chinese will think about it first. But I think for what I'm worried about from our perspective on the outside is that we, especially as the lawyer, if we don't take seriously, I think, the internal Chinese discussions on this, I think we lose out a little bit on the nuance of the way China's internal thinking is developing on this. I think a lot of scholarship tends to be a little bit too much focused on, well, they should comply, or they're not complying, or will they comply? And it's a little less than just taking sort of a look at where their views come from, how these ideas germinate within China. It's very difficult to do. I think we've improved a lot, mostly because of Chinese scholars have really done a great job in sort of improving that. But I think that type of study, I think, is worth understanding, just as we would with other countries as well. I think it's not completely a black box at all anymore, but historically it's been seen as a little bit more of a black box in other countries, which is why I do think this project that me and other scholars are doing is to try to open up the box a little bit more to the general international law sort of scholarly community.
Yes.
If this question is pushing even a little further off your paper off the track, just say so. But I'm curious. I think I've read somewhere that China has something like 500 protests every day, and there's also a the word that is used to describe it is escaping me at the moment, but there's a name for a type of lawyering that's developed in China that I guess we would call, human rights lawyering or cause lawyering. There are, lawyers who are actually engaging in, challenge to state authority through legal channels. And I'm just wondering, to what extent, if you know, do they use international law, or is there any? I guess that would. There are two distinct things: the sovereign immunity, the domestic sovereign immunity. But I wonder what's China's thinking on that, and is that changing?
Yeah, I'll say a quick note. In this case, I ventured into domestic Chinese stuff, which is always scary. But I've been studying the way they implement treaties and customary law. And generally speaking, they don't recognize customary law at all in their domestic courts. On the other hand, they do give a relatively high status to treaties as being equivalent to other types of domestic law. And so there are a lot of Chinese statutes which actually say if there's a conflict between the treaty and statute, the treaty prevails. And so that in that respect, so that they don't have the same role in that respect as the United States does, for instance. That hasn't really helped out for cause lawyers in the most part because, or what they call cause lawyers, or human rights lawyers. A lot of the big treaties the Chinese have signed but not ratified, and one of the reasons they haven't is because they're concerned about the domestic legal effects. There are also problems. People are a little skeptical of the court's ability to be independent of the party, which is and all these other domestic Chinese things. Therefore it hasn't penetrated as much into that part of it as you might imagine. Although, interesting on the flip side, China has used international law, some of their criminal jurisdiction. Their statutes say we can extend our criminal jurisdiction as far as this treaty allows us to extend it, which could be very far. And that's one area I've been curious about, whether they actually they've accidentally incorporated universal jurisdiction in some of their criminal statutes. So there's a lot of ferment there, I think, on that area. But I think hasn't been used against the state in that respect.
Yes, last question.
Okay, so thank you for a really interesting paper. You referenced this idea that sort of international law is the product of civilized nations. I would emphasize that sort of now when the courts, the Fourth Circuit, go through the litany of international law approaches, they're generally citing countries where there's an established rule of law. So this goes a bit to your question about sort of the rule of law in China and whether their engagement with the international system is actually having any impact whatsoever on rule of law internally. I think if you asked Chen Guanqian, the blind lawyer who escaped, he would have one view. But I'm wondering, sort of with your look at scholarly literature, is this having any impact whatsoever? And I'm also curious about this reference that you made to China wanting equal sovereignty, but not objecting to international bodies' scrutiny of their behavior. Given that they haven't joined the ICC, I don't see any evidence that they are acquiescing in any way to a kind of supranational scrutiny of Chinese behavior. So, do you have examples from the Universal Periodic Review or some other international mechanism where they haven't raised these objections?
Well, I'll just add that they are a member of the Convention Against Torture, and they are subjected to the Universal Periodic Review, and they're not happy about it. But then I don't think any country is. But they don't object to it in the same way that when the U.S. cranks out their human rights report every year about China, the Chinese always crank out their human rights report about the United States, and they have a good time with that. And so, in other words, the state-to-state is much worse, I think, and there's much more respect for the international organization. Although I would agree that so I think that there is that sort of difference. I think that, and it's reflected in some of their behavior. I think China, for instance, did support, at least it did not object to the International Criminal Tribunal for Yugoslavia or the one for Rwanda, and they had, I think they had some involvement in those cases. In a lot of ways, their posture is not that different from that of the United States, with there's respect. The United States is suspicious of foreign countries sitting in judgment of their officials. They're not against the principle that there are international crimes. They just don't think these foreign countries will be able to fairly do so. It's very similar to the U.S. position in a lot of respects. I think it derives maybe from a different history and a different concern. But so I think so. There's that. I think now let me just quickly note the rule of law thing. Yes, I should start with a disclaimer. It's for many people, there's no rule of law in China, so why should we take them seriously about anything else? That's true. Fair to say, although there's a surprisingly large legal community in China for business stuff, many of whom are graduates of this law school. We're just saying Duke Law School has a surprisingly strong base of lawyers in China.
Why surprising?
I'm sorry. I didn't mean surprisingly. Surprisingly early, but anyways, not surprising at all. In fact, right?
Thanks, Julian.
Quite well noted. So that they had this huge. But having said that, I think do we have a rule where we discount states' views on the way international law should work because we think their domestic legal system is not very good or actually just a joke? And actually, I think under traditional international law, we don't have it doesn't really matter what their domestic legal system is, and so we just still and so they make their views on this subject are, and they're member of the ILC. They have their views. It's not that we ignore them, even though their domestic legal system is really, really sketchy. So I think but China, of course, will not admit that. But I think they would say that that the international legal rule of law is different from the domestic rule of law.
Can I just ask
A really quick follow-up, yes.
We're in a different era now. In the United States, because of its behavior in Afghanistan, Iraq, and elsewhere, Guantanamo, the United States has lost so much of its moral authority. And so to the extent, to the extent there was a countervailing narrative, sort of China having one view, the United States having another, the moral authority of the United States has kind of evaporated on a number of issues at this point.
Yeah, maybe. But I don't know that. For the perspective of China, I'm not sure which way that cuts. We join the U.S., or whatever, what the situation is. I do think that one theme I noticed is that on some of these issues, we really see convergence of the U.S. and China. And who's on the left? And Europe is actually in many of these issues on the other side. Many European countries have a slightly different view on some of these issues. It's not exactly the same, of course, but sometimes you see this. ICC is a good example of that. And so, maybe that's also something to think about as we study these countries going forward. So.
Yes, I'm standing up because the program says that we have to end, and maybe people have to go to the airport. The program also says that I am giving concluding remarks, which is always frightening because I think we've heard a lot, and there's no way to actually summarize all the things that we've heard. I want to remind us, try to see how broad we've actually gone. So we certainly focused on questions of US law on this. I think Chris Totten in particular gave us a stunning overview of everything that has happened. But we've gone beyond that. We've gone beyond US law. So first, we've gone beyond just the legal question. We've looked at several actors. We've looked at the State Department. more strongly while John Bellinger was still in the room than in the afternoon. But we also heard from the position of advocates. So we've broadened our spectrum of actors that we've looked at. Second, we've looked, and that's particularly exciting for me as a comparative lawyer, we've looked beyond the US position on this. So we've had comparative law perspectives directly with Julian focusing on China, but indirectly at least by having two scholars here from civil law countries, 3 if I count myself, bringing not specific civil law positions, but certainly ways of thinking that are also influenced by civilian thinking. And we found something that I find exciting, that is, we find lots of citations now to international cases. Professor Bradley has become a comparative lawyer finally because Oxford now has a database for international law in domestic courts. So we can look all of that up. But you've seen in the discussion how much we referred to ICJ cases, to the Italian constitutional case from last year, the Jones case, etc. So we have this comparative aspect. Of course, we go beyond the US in that we go to international law. We go beyond the state purely in this, which is something that I find exciting. Not only by looking at human rights as something limiting of sovereignty, but also going to an idea of popular sovereignty that looks at the people as opposed to the state and bring that into the discussion. We go beyond mere law, it says here. We've had the editors invited several people who are not from law schools, and we've had several positions that were not just purely legal positions, but actually came from neighboring disciplines and looked at this broadly. And then finally, I think we've also gone beyond consensus, because we haven't always had consensus, and the very last discussion that we just had that could be never ending suggests that, and that's the most promising thing that we have, because we didn't come in agreeing, we don't go out agreeing, but we all have learned a lot, I think, in all of those respects. I think for that we should thank first perhaps the speakers, those of them who are still present in the room. Some of them I think had to go back. But then, of course, we also have to thank the organizers of this, where I have Jeb and Dominic and Annie, who I'm trying to look, maybe they're not all here. But
And he's at the reception.
And he's at the reception already, so that's so they put in, and I know they put in a lot of work because I was CC'd on some of the emails, and putting something together like this is a huge thing. I want to thank them, and I think we'll have an applause for the speakers and for them, but I also want to thank the entire journal, because this is really an important journal for the law school. We take international comparative law very seriously. We find it very important. We find the journal very important. And I say this not just for myself as the advisor to the journal, but also in the name of those of my colleagues who care about international and comparative law. And there are more and more, right? You know that Sarah Beale now says she's a comparative lawyer and has submitted an article to the journal that journal is publishing. So this is something really important, and I'm very proud of the work that you're all doing. And I'm very happy that we have this journal here. And of course, because it's late, the thing that makes most of us most happy is that there's also a reception now, which I think Dominic will still say where it takes place. But I would ask that when you now all applaud speakers and organizers and yourselves, you can already also revitalize and think about the reception, where I hope we'll all meet and talk some more. So thanks, everyone.